to the justice pathways for business-related human rights abuses in Kenya, a discussion about multi-doors approaches to justice. So on behalf of Pamoja Trust, I want to thank you all participants for joining us and your continued commitment for advancing human rights and also access to justice. So please, as you join us, tell us who you are in the Q&A section or in the chat box, the institution that you represent, and also where you are joining us from. I think it will be nice to know who and who is in the room. So this conversation will take us about 2 hours, and it comes at a particularly important moment. In Kenya and across the East African region, there have been discussions in regards to access to remedy, especially when it comes to business and human rights issues. And we recognize that while investments in infrastructural development, extractive projects, agribusiness, and urban development are taking place, and are also creating economic opportunities, they can also result in adverse impacts on communities, increased displacements, and also land-related disputes. Of course, also other issues to do with environmental degradation. So today's discussion, again, is very timely because it coincides with the ongoing national conversations on alternative justice systems. If you've been following keenly, the discussions are taking place in Embu, and one of the key issues that are emerging from those discussions is how justice can be made more accessible and also culturally relevant, people-centered, and particularly for communities who face barriers in accessing justice. Interestingly, something that is also coming out of the discussion is that justice is not just about numbers. I think the Vice Chair of the National Steering Committee on Alternative Justice System raised the issue of us always looking at the number of cases that have been filed and the number of cases that have been resolved, but we should go beyond just the numbers and look at the real question, which is the justice question. How many communities are actually accessing and can happily report that they have received justice? Similarly, for those of us who are here and were part of the discussions in the East African conference that was held last week, there were several important concerns that emerged. One, that communities continue to experience significant barriers in accessing remedies for harms associated with investments. And if we look at it keenly, also land remains at the center of many grievances, particularly in relation to community land governance, historical land injustices, compulsory acquisition of course by business and investments, and also inadequate participation in decision-making processes. Many communities still say that they're unaware of available grievance mechanisms, and sometimes they even lack resources to pursue remedy. So existing remedy mechanisms often operate in silos, resulting in fragmented and delayed responses for community grievances. As I've said, that access to information, meaningful participation, transparency still remain a key barrier for effective remedy. So as we have these discussions today, and as we also reinforce the principles reflected in the Constitution, especially in Article 159 of our Constitution, and also when we talk about business and human rights issues, we cannot go without mentioning United Nations guiding principles on business and human rights. So justice should not be understood as a single pathway through courts alone. If we look at those key guiding legislative frameworks, so communities should be able to access multiple complementary pathways that are accessible, effective, legitimate, and also responsive to their needs. So, ladies and gentlemen, today's webinar therefore seeks to explore these pathways. What do they look like? What are they? What are the challenges that communities continue to face when accessing them? What can be done by all stakeholders, including government institutions, businesses, civil society organizations, and communities to strengthen remedy? So our discussion is just all about how do we strengthen remedies while recognizing that we have these different pathways to justice. Just to mention that we will be having a series of webinars to unpack what justice means in business and human rights. And as you continue, my colleague will also be sharing a link to collect ideas on some of the issues that we might need to deliberate on. So today, and now to the interesting part, we want to hear from very seasoned experts, experts in the human rights field, to help us unpack some of the issues and to set ground for us for these deliberations. So I'm very privileged today to introduce to you two of our speakers. That is Mr. Cyrus Maweu, who is here with us, and Mr. Samuel Orlando. And just to introduce them better, I'll just read a bit of their bios, what they're about. So Mr. Cyrus, as I've mentioned, is a seasoned human rights and access to justice expert, and he holds a Bachelor of Law degree from the University of Nairobi and a postgraduate diploma from the Kenya School of Law. And adding to that, a Master's of Law in Sustainable International Development from the University of Washington, USA, and another Master's of Arts degree in Development and Governance from the University of Duisburg-Essen in Germany. He's a legal practitioner. He has diverse experience in human rights and social justice sector. He has worked extensively with the National Human Rights Institution, civil society organization, and he has also processed complaints, including the provision of appropriate legal advice, investigations, research, and advocacy. Mr. Maweu has been involved in constitutional and public interest litigation in Kenya. So as you can see, he's a very seasoned expert, and he has also done issues to do with criminal investigation, and is also a certified professional mediator with a wealth of experience in legal research. As we talk about alternative justice systems and also pathways to justice, Mr. Maweu is also a member of the National Steering Committee on AJS. So we will welcome him for him to be able to talk to us about how does pathways to remedy look like. But before he comes, allow me to also introduce the second speaker, so that when he comes, he just continues, who is Mr. Samuel Orlando. Mr. Samuel Orlando is the Executive Director of Pamoja Trust. He also has extensive experience supporting communities on land rights, social justice, housing rights, and accountability processes. Most times he likes to introduce himself as an activist of human rights issues. So he's a trained, academically, he's a trained urban sociologist and a lawyer in the social justice sector, and has engaged in socioeconomic rights advocacy in national, regional, and international levels. He has made major contributions to development of policies, legislations, and regulations on land governance and development from the lens of defining solutions for urban informality and rights for the vulnerable communities. At the global level, he has worked with the United Nations Committee on Economic and Social Cultural Rights on issues like Universal Periodic Review. And you'll understand why when you talk about Universal Periodic Review, they're very important on business and human rights issues. And he's also a Pan-Africanist, or a Pan-African. So as you can see, the two speakers today have wealth of knowledge, both academically and from practice. And we will take this opportunity to hear more from them. So I want to encourage all participants to actively engage. I know we have disabled your mics for now so that we're a bit orderly, but we'll be able to allow you to also engage verbally and also through the platform of the Q&A. So welcome again, all members. And now I want to take this opportunity to welcome Cyrus Maweu to talk to us about access to remedy in practice. What does it look like when we talk about land issues that continue to dominate complaints around infrastructure? What does the policies around the UNGPs and the Constitution talk to us and enable us to access remedy? So welcome, Cyrus Maweu. The floor is yours.
Thank you, Sandy.
You're welcome.
Thank you very much. I hope you can hear me. I hope I'm also visible. So from an access to remedy perspective, you look at it from different parts, and you've already set the context that we are also in a country that has embraced alternative justice systems, and our constitution actually obligates the judiciary to promote the application. including even the traditional dispute resolution mechanisms that are more prevalent in some of the communities that are in this country. Now, historically, before the colonialists came, we had our own ways of resolving disputes. That continued past colonialism, and we still have the parallel or the plural system of legal laws applying, where some communities apply customary law and others are applying the formal law as we know it. In terms of access to justice, there are those who will go to court, and there are those who will go to other mechanisms that need not actually be state. But we also have state-based non-judicial remedies, such as the different administrative processes that we have. If you look at what, for instance, at the very basic, what the Ministry of Labor does, what the Children's Department do almost on a daily basis, they sit to hear and resolve disputes, some of which actually touch on communities, and they enhance access to justice for these communities that may not have access to these courts. Businesses are also encouraged under the United Nations Guiding Principles to have operational grievance handling mechanisms, much more than the ordinary complaints and suggestion boxes that we've seen, but a mechanism through which affected community members can submit their complaints and have them resolved, and that which can also facilitate the tracking of the trends of the complaints that are being resolved, and also gauging the effectiveness of some of these operational grievance handling mechanisms. It is highly encouraged that these mechanisms be community friendly and fit for purpose by the communities, because at the end of the day, they are meant to serve the interests of these communities. Again, the UNGPs, the United Nations Guiding Principles, have provided a very clear criteria under Guiding Principle number 31 on what needs to be done or how those mechanisms can be set up. And they provide for a number of things or a number of characters, such as how legitimate these mechanisms are. And this is about stakeholder confidence. How are they developed? How is the process itself? Do they protect the business, or are they independent from the business? And how functionally effective are they in terms of serving interests for the communities? There's also something about accessibility. Are they open? Are they widely known? Is information on their existence known by the community target? And how predictable are they, so that those who submit themselves to these mechanisms would know some of the procedures that they are likely to go through? It's only then that they can also question when something is not going as right or how it should be. Again, elements around transparency, accountability, they should also provide a basis for continuous learning, and they should be based on dialogue and engagement, since they are meant to serve the interests of these communities. I think I can stop at that for now and cede the floor back to you, Sally. Thank you.
Thank you so much, Bwana Cyrus Maweo. I think you've rightfully put it, that remedy needs to be community friendly and also fit for purpose. And you've also highlighted some of the challenges that need to be addressed for communities to access remedy. As we continue to discuss today, I think some of the issues that we also need to look at is that what are the greatest obstacles preventing communities, especially those who are affected by business activities, from accessing effective remedy, and what practical solutions would we propose? One of the issues that are coming up, because we've always talked about remedy, what should be done before harm exists? Should we give a lot of focus to remedy, or is there something else that businesses and even those who we call duty bearers should put into consideration even before we start discussing issues of remedy? I know these are issues that Bwana Orlando, you're passionate about, issues to do with safeguards and how communities and just all the stakeholders can engage together to make sure that harm is prevented even before we reach a remedy. So what are those practical solutions that communities can have before communities and also businesses and the duty bearer should put in place to prevent harm? And if harm happens, then what next? Over to you, Bwana Orlando.
Thank you very much, Sally, and for the very generous introductions that you gave me. For a moment, thought that I had forgotten um, myself. So then you asked us a very specific question as to what should happen before we go to remedy. And as such, then that calls us into interrogating the proactive role the various players that should play to ensure that we do not go to the extent that harm occurs. And as such, then, this then starts raising questions around particular instruments that we can embed within our communities, within our businesses, that then would be like questionnaires or like those things that then point to us that there is potential harm that may occur. And this may oscillate around having earliest entry points to potential harms. This could be in relation to policies that guard around labor and labor relations. This could be around policies that deal with issues around sexual exploitation, abuse, and harassment. These could be policies that guide around resettlement action plans. This could be issues that revolve around development of project grievance, redress mechanisms, and many more that are then embedded within our systems to ensure that they become tools that we use as a basis of preventing harm from occurring. And in doing so, then it is important that then communities, companies journey as a society that are within the same locality to address some of these vulnerabilities that may arise. And as such, actually, when you read the majority of our laws, they notice that we anticipate this by developing what we call safeguard instruments in terms of project implementation. And these safeguard instruments are to safeguard and prevent potential harm from occurring. For those who are in the environmental sector, environmental social impact assessments. Again, for those who are in the settlement sector, resettlement action plans. Being documents that normally the regulators require for purposes of allowing particular investments. So normally in institutions that perhaps are not doing hard investments, we normally have human resource policies.
Sorry, Orlando, we've lost you for a minute there. Can you hear me?
Yes, I can hear you. I don't know that you can hear me.
Yes, now I can hear you. I think you can continue. We lost you for a bit, but we can hear you now. You can continue.
Thank you. So then, as I was saying, is that some of the documents that will guide are those that may be company specific, or those that are regulator oriented and that are given to us by statutes. And statutes here mean laws that Sarah was speaking to. And in terms of statutes that the regulators normally put in place to ensure that we do not expose communities to harm could be documents around environmental and social impact assessments. I know now there's a bit of a push to have regulation of social impact assessments other than the environmental bit, which has grown over time in our jurisdiction. We have those that are embedded in companies that are related to having settlement action plans, having human resource policies that then allow companies to have robust earliest opportunity as entry points in dealing with the potential harms and then ultimately that will lead us to remedies. Thank you, Sally.
Thank you so much, Bwana Orlando. Even as we talk about social safeguards, I just want to raise the issue of there have been some situations where communities experience harm but really struggle to prove it. And I know, Mr. Maweu, because you've also worked around investigations and you've also worked with the Human Rights Commission, you understand that issues of documentation when you talk about harm is very key. So how should communities navigate complex legal and administrative processes? And I'm talking about from an access to justice perspective. What are the biggest barriers that prevent communities from obtaining effective remedy when we talk about documentation? And what are some of the possible solutions that you can provide to the communities as a solution in regards to documentation? Mr. Maweu.
Thank you, Sally. And that's very true. That oftentimes the constitution and the legislation will just provide the rights, but it is equally important that there should be remedies for these violations. I'm sure you appreciate, even when we're having ordinary conversations as citizens, we ask ourselves, so what happens when you don't perform your part of the agreement? Even in land transactions, people would sit down, agree, and much as they trust one another, they also ask themselves, so what if this doesn't go as we have planned? How do we handle that? Now, for communities, access to justice means much, much more, because it's not just about access to the mechanisms, but also what they get out of that mechanism and how to prepare, even in terms of presenting their cases, as you've already asked. So one of the challenges is how the evidence, especially if you're approaching it from a litigation perspective, we are in a very adversarial system of justice. It's the person who alleges who bears the burden of proving, and most of the times the allegations that are being litigated about are very, very complicated. Think of some of these environmental pollution cases where one has to necessarily establish the scientific link between the allegation and what is manifesting in the nature of the different human rights violations. So that is a very oftentimes complex process, because you need technical experts who will not come cheap. Again, that raises the question of the expenses, and the communities are oftentimes not the most financially endowed, and they also lack the technical capacity and the tools to gather what would otherwise be considered admissible evidence in court. Now, that challenge is further compounded by the fact that representation is also not very easy, and it's also not cheap, especially if you think of hiring the best advocates to put across or litigate and present the case before the courts. The filing fees, at times, I'm sure the judiciary is trying its best to make sure that fees that are being charged are not in any way restricting people from accessing court. But the reality is that even when it's nominal, there are communities and individuals that may not easily afford the fees and the costs that are attended to litigation. Again, also think of even accessibility of the courts themselves, the geographical presentation of these courts. There are some, it may shock you that we are in a country that one of the counties does not have a high court station. Now, for some of these cases, they require the specialized courts, whether it's the Employment and Labor Relations Court or the Environment and Land Court, which is not physically present in most of these regions, especially where the community members reside. That presents another challenge in terms of, even when you've tried your best to document, where do you move past the documentation? We also are in a country where, appreciably, a majority of the Kenyans are highly empowered, but there are also regions where human rights awareness is very limited. So even for citizens to claim that right, they must first, as of necessity, be aware of the right. That is the only way they will appreciate when they are violation, and also be able to pursue the different existing remedy mechanisms. Now, having said all this, there is also the fear of intimidation and retaliation, because oftentimes they are up against very powerful and very influential multinational corporations or even local businesses who sometimes use not the best of means to intimidate and harass, and that is why we have very many cases of human rights defenders who are subjected to intimidation and threats for the work that they are doing. To overcome this, I think part of what needs to be done is a lot of sensitization and awareness on matters human rights, not only the right in terms of the normative content, but also whenever there's a violation, what are the remedy mechanisms available? To the extent possible, there's a need to partner, especially with local CSOs, as well as human rights defenders who are oftentimes directly in touch with the communities, and they can help escalate and also support in the documentation of some of these violations. There is also a need to properly and adequately resource some of especially the HRDs who are very vocal in these matters, with the necessary tools that will help them, and the information as well that will help them put together and document some of these violations. There is also the need to ensure access to remedy is practical, and to the extent possible, some of these mechanisms that don't require really a lot, especially the administrative ones, are readily available at community level. Thank you, and back to you, Sally.
Thank you, Maweo. And I'd like to mention that this webinar is also hosted in partnership with Dan Church-Aid. I know there's a representation, Joan and the team is here, and also CJ, under a project that we are calling the Cultivating Justice Project. And Maweo, as you have put it, and I think it's something that we've also observed in our discussion, intimidation and retaliation. Because when we're talking about business and human rights, we're talking about businesses, and we acknowledge that businesses have financial muscle compared to the communities that are around them. Some of them are multinational, big investment or big businesses. And sometimes that's a big barrier, because communities see it as they can't go against such businesses when such businesses can be able to afford good and quality representation when it comes to, for example, representation in court or representation during litigation. And you've also talked about a solution, which is remedy mechanisms that are available, sensitization for these communities to be able to know. We know that there has been a challenge to accessing one of those mechanisms, which is court. And communities have continuously pronounced themselves that on the matter that they prefer to use community-based or grassroots-based access to justice or access to remedy mechanisms. For example, the local administration platforms that are available, like the chiefs. Do you think that these other pathways to remedy are fit for purpose, or are fit enough to be able to resolve the issues that come with business and human rights issues? And as communities are also aware of these remedies, how do we strengthen such other pathways to remedy so that they're effective enough for communities to be able to experience justice? Maweo.
Thank you, Sally, for that. It's actually the lived reality. You may go to some place and you will never find some of these communities approaching the courts for resolution of their disputes. Way back around 2017-19, there was a justice needs survey, and the documentation was very clear that about 79% of Kenyans who had a justice problem never approached the formal justice mechanisms. So the question becomes, where are they able to have their justice needs resolved? There's a tweet by the CJ which said that the courts handle around 11% of the cases that arise in this country. Now, if you look at the backlog that the cases are grappling with, and they're only handling about less than 20%, then where does that leave us? The conversation then needs to objectively shift and look at where people are accessing justice, or where they're having their justice problems presented and resolved. So that makes the case for us to equally invest in that. Again, if you look at the approach, the approach by the judiciary, it's already embraced these other mechanisms. There's even a report of the judiciary looking at traditional, informal, and other modes of dispute resolution that Kenyans are using to access justice. And that policy document the lived realities, and they found that a majority of Kenyans are really not going the court way. So how do we strengthen these mechanisms? From where I sit and the way I look at it, is to have them formally endorsed and accepted as equal avenues for people to access justice. And I'm happy that the judiciary has already provided leadership in that aspect, and even its leadership, especially the Chief Justice, has spoken quite heavily about access alternative justice systems. There's even a committee that is tasked with overseeing the implementation of alternative justice systems. There's even clarity on how these mechanisms need to interface and interact with the judiciary, so that as and when Kenyans resolve their disputes out there and they need that outcome or whatever settlement they've arrived at enforced by the judiciary, then the judiciary does not look at them like people who are usurping their mandates. People are not, for lack of a better term, running in courts, kangaroo courts, but people who are helping them resolve these justice needs of the Kenyans. Again, if you look at the conversations that are already ongoing, there's that genuine desire to see how best there could be referrals between these mechanisms and the formal judicial mechanisms. So again, that's another avenue that we can leverage on and see how best we can have these mechanisms continue to effectively serve the justice needs of Kenyans that they are already doing. And finally, for me, is documentation. How can we have what is happening out there documented for purposes of even learning, for purposes of even transforming these mechanisms, so that we draw from what is already happening and we strengthen what is happening. Moving forward, there are key lessons that we can pick, and that will be for the good of everyone in the Republic, especially because access to justice is one of the rights that should never be limited, and it's never been limited since time immemorial. And the courts cannot really handle everything. That is the sad reality or the lived reality of a majority of Kenyans. And there are people who do not formally go through the formal justice system. So you'll file a case in court, you'll not have witnesses showing up. So at the end of the day, it doesn't really serve the purpose for which it was intended. So there's every reason to support those other alternatives. Thank you, and I cede the floor back to you.
Thank you, Senior. And now to Orlando, and something that you're passionate about, which is land. The discussions that we had even at the East African Conference placed land at the heart of grievances when it comes to business investments. And I know Pamoja Trust has worked extensively when we talk about land rights, and also with communities that are facing evictions, and of course also with development related harms. We have seen some of the recurring challenges, land being at the heart of it. We know big businesses, for example, and sorry to mention names, Del Monte, Kakuzi, the tea farms. These are some businesses that have always had challenges and discussions on land, historical land injustices. What is the best possible way or solution that you can suggest that can bring these issues of historical land injustices to a halt? How can communities get justice, especially when we talk about historical land injustices and land issues in general? Orlando.
Thank you, Sally. So then perhaps I'll give a bit of stories on this, and start with perhaps what predates the colonial Kenya. And you would notice that to a larger extent, when you had particularly the Trustlands Act in 1938 and what happens with the Carter Commission that then took us back to land being privatized to a larger extent that I never paid a lot of attention to the role or to the holding, to the tenure systems that the African communities had. And as such, you notice that land is one of the biggest legislated, sector in Kenya. I was reading through as I was preparing for this, and I noticed that we've got approximately 77 statutes that are related to land, be it in water, be it in forest, be it in land as land, registration, and the various holdings. And you link this to remedies, then you would appreciate that remedies, we look at restitution, we look at compensation, we look at rehabilitation, we look at something that guarantees non-repetition of the harms that occur. And as such, we would notice that Kenya formed what we were calling the independent commissions. And the independent commissions, to a larger extent, is not a new concept. It is a concept that started in the US due to the political interference of in administrative functions of various institutions. And as such, then in Kenya, we have independent commissions, and the Kenya National Commission of Human Rights, where Cyrus comes from, is one of it. In the land sector, we have got the National Land Commission. And when you read the National Land Commission Act, some of the remedies that it provides for historical land injustices or injustices they may occur includes restitution, include compensation, include rehabilitation, satisfaction, that sometimes are just public apologies and acknowledgement of the harm that occurred, and also something that guarantees non-repetition. Now, when you further read the statutes that constitute these particular commissions, be it the Kenya National Commission of Human Rights, be it the National Land Commission, you would notice that they have got powers to summon and do investigations on human rights violations. And in many occasions, people refer to them as the fourth arm of government. And as such, my only fear is that they may go to start behaving like the formal justice systems. And perhaps Cyrus will speak to this, because I was listening today to the regulations that are guiding the filing of historical land justice claims that has been proposed by the National Land Commission. And the threshold, Cyrus, that perhaps will come to, creates the threshold that comes to the formal justice systems that communities are trying to run away from. And that's why, to a larger extent, when there is a violation, then it starts with communities first going to their traditional dispute or customary resolution forums or local leadership structure. And this is something that we have experienced in the majority of communities that we went to. So they will go to their clan elder and say that, my piece of land has been annexed, our grazing land has been affected. They will seldom go to the formal justice system, which is the court, and complain. They will go to the area chiefs. They will not even go to the registry, the land registry. And as such, then, you notice that the place of independent commissions, which to a larger extent are national human rights institutions like Kenya National Commission of Human Rights, give us the basis upon which then we get an entry into remedies that are provided. And why is it that in the National Land Commission Act, we had the remedies being in the National Land Commission Act and not the other statutes as such? You notice that it's because of the history that to a larger extent, the political elite who occupied the legislative arm and the administrative arm of government did interfere with the remedies as was being sought by community. So as such, then the argument was, okay, fine, if you have got an independent commission in the National Land Commission, then perhaps those who have got historical land injustice claims, then you'll have restitution, you will have compensation, you will have rehabilitation. And that there has been, we'll have guarantee of non-repetition of some of these things. However, as they put it, there's interdependence in independence, such that then, and Cyrus perhaps will also speak to this, commissions are not as independent as they are, because they still rely on budgets from the National Assembly. They still require the president to appoint and have them gazetted, even when they go through vetting by institutions that are not aligned to the executive wing of government as such. So as such, then it comes back to what then gives communities autonomy, so that then we build a community that then is independent, that then they can apply this particular statutes to not only guard their rights, but ensure that land is used in a sustainable way that do not harm communities. And that brings to fore the place of human rights defenders engaging with independent commissions as a basis of claiming rights. And this could be in terms of land displacement, labor rights violations, environmental harm, legal aid and services, calling upon the national the commissions to do public inquiries and publish their reports to Parliament that can again be relied upon by these communities if they are to choose to go to the formal justice systems. And then later come back perhaps early to why this neoliberal thinking of how independent commissions and even what we have in the Community Land Act, where we have got autonomous community structures, could still then be problematic because of the concepts that are underlying therein. But I hope I've covered what remedies would be and why we needed independent commissions in the land sector, and why autonomy of communities is still important in ensuring that the rights of communities are upheld if we are to realize our interests in the implementation of the National Action Plan on Business and Human Rights, and why consistently we must insist that independent commissions then lead these particular processes. As such, this will then give communities the necessary audience to be able to air their thoughts and also claim their rights. Thank you.
Thank you so much, Orlando. As you can hear, for participants, you can tell that Orlando has extensive knowledge when it comes to land issues, and he has rightfully put that communities are still very key when we're talking about remedy. They should be there to proffer some of the solutions that communities need. We're talking about community autonomy, we're talking about HRDs, and I know today there's also representation from HRDs from the 3 regions that this project is active in. I think HRDs continue to be the immediate responders to some of the harm that communities experience. And as you put it, Orlando, that even as we have legislated on land issues, we have solutions when it comes to the remedies that are available when harm happens in relation to land issues, and that commissions are custodians to justice. It also appears that there are still challenges when we talk about interdependence of these commissions. And in that regard, I think if I hear you well, you're saying to deal with this independence issue, communities should then be there to help us resolve some of the issues we're talking about. I think we have legislated, we have had a lot of legislations when it comes to land, as we've put it from your research, that we have about 77 legislation. And I know as a country, we also have a legislation on business and human rights, which is the National Action Plan on Business and Human Rights. And some of the progress that has been made is how businesses can handle some of the disputes that emanate or from some of the impacts that come from the businesses. And we're talking about the OGMs, the grievance redress mechanisms, and we have beautiful policies, just to say. So just to add to it, Cyrus, going beyond the policies, dealing with the challenges that comes even with the good solutions that exist within the pages of our policies. How do we deal with issues to do? And I think this also connects with issues to do with retaliation, corruption. How do we then ensure that even as we have good policies, for example, the National Action Plan on Business and Human Rights, the policies within business institutions, the businesses itself, for example, the human rights policies, the specific human rights policies within the businesses. How do we ensure that communities, I know Lando has talked a bit about that, but just to add onto it, how do we ensure that communities are still at the heart of remedy, and especially the human rights defenders? To you, Sarah.
Sally has just weighed in and add to what my good friend Sam Orlando has already pointed out. For me, I think the starting point is how we design even these remedy mechanisms. What is the role and where is the voice of the communities in some of these mechanisms that are designed to help them resolve their grievances? And my suggestion is there should be a way and a modality of meaningfully engaging these communities in the design, implementation, and even monitoring the effectiveness of some of these grievance mechanisms, so that it's not just designed out of the blue, but is alive to the lived realities and is relevant to the specific needs of the communities wherein it's expected to operate. And that also means that there's a need to sensitize and create as much awareness as possible to the communities on the need to use these mechanisms and their existence and the extent to which they assist in resolving their disputes. So I also suggest that it's time to have paralegals and other actors, including human rights defenders, meaningfully engaged as and when some of these remedy mechanisms are being set up. And even in translating these mechanisms into local languages and disseminating them in a manner that is easier and well appreciated by the communities. Nothing stops us from having those conversations in the local vernacular languages, if that's the way that the communities would better appreciate and understand how these mechanisms are supposed to function. Again, strengthening the law. We already have enough laws, as already pointed out by some, but we also need to ask ourselves how effectively the law is implemented. For instance, it may shock us that as of 2021, that will be 5-6 years after the Community Land Act was enacted, only 6 community titles had been registered. I don't have the current statistics, but that should shock us that over a span of about 5-6 years, only 6 communities had registered their lands. So to what extent are we using the law to protect the needs of the communities? Because that legislation was meant to operationalize the registration of community titles. In terms of protection against retaliation and intimidation, I think it's basically about further conversations, especially with the businesses, the different actors, the state itself, to appreciate the work of human rights defenders and not penalize the exercise of human rights. Again, for the businesses, wherever they operate, I think it's very important for them to meaningfully engage the communities, work with them, and simplify, especially where they have grievance mechanisms, into the local dialect. And I believe if this is done, it may contribute to better functionality of these mechanisms, better human rights awareness for the communities, and more significantly, if well applied, better realization of human rights by some of these communities who may not have access to the formal justice mechanisms for the reasons that we had already discussed, including the technicalities and the expenses involved, and even the physical accessibility of the courts. Again, questions around information on all these remedy discourse, because we cannot expect that people assert a right that they are not aware of. Thank you, and back to you.
Thank you so much, Senior Mawil. And I know we are also joined by Joan Kirimi, who's also a guru when it comes to issues of business and human rights. From your observation, Joan, and thank you for joining us today. From your observation, which are some of the remedies or solutions that you have seen in practice that should be strengthened to ensure that justice is realized? Karibu, Joan. John, can you hear me?
Hi, Sally. Can you hear me now?
Yes.
Yeah, my apologies for that. I was trying to rejoin, and this has been a very interesting conversation, and particularly from the two experts who are sharing quite a lot of insight on this matter. I think what Sarah has already said, and then of course also Sam, there's an element of community involvement and rights holders involvement when it comes to one, defining justice, but also using all the frameworks and systems and processes that exist to ensure these rights holders can access justice. What I mean is a lot of times there's a lot of prescribing what justice looks like, a lot of kind of defining in advance what justice means. But I think at the heart of it, community involvement, multi-stakeholder engagement as well on defining what justice looks like, and therefore what is relevant to these rights holders is very, very important. So I think that's a key element to ensuring that justice works. And because of consultation, then you will hear from the rights holders, from the communities and from the relevant stakeholders, then how the process of getting to justice, how they want to experience that journey, and how they want to engage at whatever level. I think of operational level grievance handling mechanisms. These are mechanisms with or by private sector handling grievances of the different stakeholders. I think that when communities are actually engaged and involved, there's a better appreciation of how these OGMs work, a better appreciation of the system, and you can hear directly from communities whether that system is working for them, what aspects of the system are not working, what aspects of the system can be improved. So I think, just to reiterate also what Sarah and Sam are saying, the systems are there, we have very good legislation, we have very good policies, but it is in the experience, it is how rights holders are experiencing these systems, these policies, these frameworks that needs to change. And that can only change when there's consultation, when there's involvement, at even from the point of designing some of these frameworks. When there's that consultation, that engagement, then that journey to justice and eventually justice will make sense for the communities and will realize actual justice. I hope I caught the entire question, but yeah, that's what I think.
Yeah. Thank you, Joanne, for those sentiments. I think what's also coming out is that the question of whose justice, and this is also something that Sam always likes to ask: whose justice? Justice by who, for who? And I think what you're saying is that for us to experience justice, that all stakeholders need to be on board, communities need to be at the heart of it. And I think this also connects to the discussions, Joanne, that we had last week on moving beyond compliance. Thank you, our speakers. I can see some questions that are coming. There's a question, and any one of the speakers can be able to respond before we continue. There's a question from Dennis Maina. He's asking that as we promote community-friendly remedies, HIS and mediation, have been important avenues for resolving dispute at community level. However, recently we encountered claims that advocates should not participate in mediation processes involving non-advocate mediators. Do the UN guiding principles support such a position? That's HRD from Mungoliba, and I think Maweu, I think you can help us answer that.
Thank you very much, Sally. I'm seeing a response from Mr. Wafula, who expressly states it's a no, and the UN guiding principles on business and human rights do not support a blanket position that advocates should not participate in mediation processes merely because a mediator is not an advocate. So I've just read the response that Mr. Wafula has provided, but the spirit is for communities, it's about what works for them. Remember, at the end of the day, alternative justice systems is about agency and the people exercising that agency and determining what remedy mechanism they want to resolve. It is purely party driven and it's completely voluntary. So if two parties agree to have their dispute resolved through a mediator who's not an advocate, there's nothing wrong with that. At the end of the day, it's about the remedy that they get, and they themselves determine whatever mechanism or what procedure they want to subject themselves to. And even for the court's annexed mediation, the court provides a list of mediators. So even in that process, parties have the opportunity to choose who they feel more confident in, whom they want to have them assist them in resolving their disputes. Again, if you look at the United Nations guiding principles, Mr. Wafula has already stated the position, and they do not go into such details as who should sit in the grievance handling mechanisms for any of these forums. Traditionally, parties have resolved their disputes through the traditional dispute resolution mechanisms. They still continue to do that. Those disputes are not handled by advocates. So there is all the evidence, lived experience that one need not be essentially an advocate for them to assist in resolving disputes. It's about what works for the communities. It's about what they have confidence in. It's about how they want and how they've chosen to have their disputes handled. I think I can stop at that for now, because at the end of the day, all what matters is once that mediation has been done, with the mediator, advocate or not, especially for court annexed mediation, be able to bring that settlement agreement to the court for adoption and enforcement. And again, let's also appreciate that it doesn't have to be through a mediator. Parties can agree amongst themselves. They record the agreement and they bring it to the court for endorsement, adoption, and enforcement as an order of the court, because the law expressly allows for private settlement agreements to be filed in courts. Thank you.
Thank you, Cyrus, and thank you for mentioning that. There's a comment from Asena, and I think it's just a comment. I think she thinks that we should have a standalone Ministry of Business and Human Rights that is fully budgeted for and allocated funds to specifically look into the human harms issues. I think intentionally or internationally, yes. So there's a proposal there that we should have a Ministry of Business and Human Rights. I don't know what we all think, given that we also have the Commission of Human Rights that is the institution that is mandated to look at human rights issues. And of course, also we have the Office of the Attorney General, that is the Department of Justice also that deals with such issues. Yes, I think it's something that we can deliberate on. There's also a comment from James Mainanganga. He says that we celebrate judgments, but sorry, I think the question has appeared. Sorry, I've just... Yeah, I can see that this question has been answered, but it was to do with celebrating judgments, but who follows up to make sure communities actually get land back, compensation or cleanup, or is there a monitoring body? I think this has been answered. Has it been answered? I think Sam alluded to it. Maybe Sam, you can talk a little bit, you can respond just shortly on this. Who follows up to make sure that communities actually get their land back, including compensation? And he's also saying cleanup. I don't know what he means by cleanup, but maybe if you can just say something to this for Orlando. Orlando, you can hear me? Sorry, as Orlando comes on board, I think there's something that has continuously been mentioned on social safeguards. What should be done by businesses to ensure that harm is prevented even before we have discussions on remedy? And I think Orlando alluded to it a bit. I can see, Orlando, you're here? Alluded to it a bit on businesses making sure that they have social safeguards in place. And I just wanted to ask, and John, apologies for ambushing you this morning or this afternoon, but I'm just thinking about, yes, Orlando is here. I think I'll ask that question after Orlando has responded to the question.
My sincere apologies. My laptop was acting up, so I could hear you and you couldn't hear me. So then, the question you asked is as to what I think about that. I think I'm a proponent of the doctrine of exhaustion, and that's why I normally encourage communities to make use of the Kenya National Commission of Human Rights, to make use of their local leadership structures, to make use of their traditional customary dispute resolution forums, to make use of the company level grievance mechanisms, because of one reason. Not that they cannot go to court directly, but because when you exhaust this particular structures, then it allows you to build the relevant community of knowledge. You can imagine the knowledge that Cyrus Mawe and colleagues have at the Kenya National Commission of Human Rights, the knowledge that resides at the National Land Commission, the knowledge that resides in the environmental tribunals that are established with the Environmental Management Coordination Act. You can imagine, the knowledge that resides on the Commission of Administrative Justice, the knowledge that resides with the chiefs and such. After which, then we go to now the courts in the event we are able to find a solution as a final stage at the formal justice system. And as such, then you will have built a very strong foundational basis. And this brings us to one of the famous cases that I know colleagues can read about, the Kibos Distillers Limited versus others. And the court for the dispute was basically around the economic and environmental conservation and public health discourses in Kisumu, that's River Kibos, where we had the human rights defenders being the petitioners who are living near River Kibos. And the details were basically on grievances related to the toxic effluents that are coming from the factory, the untreated wastewater from Kibos River, and some of the landmark rulings that were coming from the Environment and Land Court, the Court of Appeal, and ultimately the Supreme Court. You notice that the doctrine of exhaustion then plays a major role as such. Then the second strand to this particular approach would be that can courts issue structural interdicts? And this is something that Cyrus has dealt with, that ultimately, where there are violations of rights and structural interdicts are issued, then the Kenya National Commission of Human Rights then comes in to play a major role, to supervise the implementation of the remedies or the reliefs that the court has provided. And this has happened, you remember the famous Soweto East Zone A housing infrastructure case. You remember the famous Mutual Welfare Society case that you had structure of interdict. And as such, then, making use as human rights defenders of the constitutional commissions then becomes very important to ensure that rulings and judgments that come from the court are supervised or implemented. But then ultimately, using these particular reports in other avenues, be it nationally, regionally, and internationally, when you submit shadow reports to the various committees, when you engage in the various special rapporteur on various questions around rights and violations of rights. But as I pack that, Sally, I think for purposes of the academy, there could be a contestation between what could be state or statute-based institutions and traditional institutions. The statute establishes, the role of the office of the chief, establishes the Community Land Management Committee, like in the Community Land Act, establishes the codes. But we do not have statutes that establish, local leadership structures like elders and settlement committees and traditional customary dispute resolution mechanisms and community grievance redress mechanisms, other than acknowledgement in Article 159(2)(c) of the Constitution. So this contestation is a contestation where communities identify with traditional leaders as their spaces for dispute resolutions, and in the basis of traditions and occasions that involve what can be referred to as customary approaches to customary authority that they have as community. But on the other hand, the state and state officers say that, but we are established by statute, so that then to deal with this mischief which they normally Christian community structure as kangaroo systems, which is to a larger extent is a misnomer. So as such then, how do we then use our traditional dispute resolution mechanisms and those that are established within the companies, within the communities, to escalate to the independent commissions, and that then we create that particular bridge and deal with these disputes? Because traditional systems create community lobbyists who are very important to ensure that particular threshold of rights are attained. They are political power brokers, because in most occasions these disputes are also oscillate around politics, so that then they can not be ignored. But they are also a repository of knowledge in terms of the manifestation of environmental, land issues and violations in communities. So this particular approach then is not only productive to the businesses and the state as is, but ensures that we build nationhood where communities are the drivers of their development, and that they collaborate with the private sector to ensure that we give birth to a just society. So then, Sally, I hope I didn't go over and above what your intention was, but then I wanted to cover it in those two strands. Thank you.
Thank you. That's unmuted. Thank you, Orlando. That's very interesting, and it also brings the issue of advocacy as also an approach to remedy. Thank you for also mentioning that traditional systems also creates community lobbies, I think, which is very key when we're talking. I think that's also a solution in dealing with businesses as having financial power and the retaliation issue that we were talking about. There are a lot of questions that are coming up, and I want to open it up. Before I read some of the questions, allow me if we can give the mic to Felix Muridi. I can see your hand is up, so that at least we also hear from some of the participants and not just the speakers. Felix, can you now, do you have the mic to ask your question? You can go ahead if you do.
Yes, Sally, can you hear me?
Very clearly, go ahead. Felix, you can ask your question.
Okay, I first of all is to appreciate what the speakers have talked about. I think this is a very timely discussion, and I wish we'll have it in person so that we can get to even interrogate more on this. Mine, I don't know if how this will be addressed, but the issue of compensation after the Gen Z protest and how the president talked about the compensation. So maybe I don't know if the speakers can help us understand how that was arrived into in terms of payment, the fee in terms of, and then yesterday we saw there's a group that came out and said that they don't want that compensation. So what happens if people will not accept that compensation? Thank you.
Thank you, Felix. I think you can also give, before that is answered, we've taken note of that question. It will be answered. Lewis Wafula, we want to give you the mic so that you ask your question orally. Do you have the mic now? Are you able to talk?
Yes, I'm able to
Yes.
talk. Okay, mine is to Sam Orlando. The first question will be, what practical strategies can be adopted to revive and strengthen the underutilized or defunct commissions, so that they can effectively contribute to AGS and ADR mechanisms? And the other question was on the involvement of women in ADR and AGS initiatives. How can we promote them so that they can rise above their cultural limitations and become active participants rather than sidelined participants? Thank you.
Thank you, Lewis. I think we can start with Orlando answering Lewis's question, and then Senior Cyrus, you'll answer for us the compensation question. And then I'll also allow Joanne to give a comment before she steps out. Karibu, Orlando.
Thank you, Sally. So, one of the practical strategies to strengthen commissions on AJS and ADR mechanisms is in itself in the Kenya National Commission of Human Rights Act. Even that statute that then constitutes the Office of the Ombudsman, the National Gender and Equality Commission, the National Land Commission. You notice that as a right holder, you can petition Kenya National Commission of Human Rights to investigate a human rights violation. So you can first strengthen by making use of the institution. And one of the tools that independent commissions have that cannot be done by perhaps the formal justice system like the judiciary and such is that they can do public hearings. And Cyrus here will tell you that they have done a number of public hearings, and that these reports are then submitted to the National Assembly for purposes of remedies that are sought. And I want to give you an example, again, as someone who has been in the advocacy sector. There's a time that, and in the formation of the Kenya National Commission of Human Rights, the government was not very keen to constitute it. So what happened? That was the birth of Kenya Human Rights Commission, that communities developed their own commission to generate reports and petition government to constitute the Kenya National Commission of Human Rights. And that's why the Kenya Human Rights Commission came to be. And after some time, then we had the Kenya National Commission of Human Rights, that was now a constitutional commission. So as such, then, how do we organize ourselves to make sure that the statutory role of the Kenya National Commission of Human Rights is played by invoking what is in the statute, by engaging the National Assembly when we have the public finance management process to ensure that the independent commissions are funded to check on the excesses of the state, particularly the executive and the legislature. Involvement of women in ADR is about affirmative actions, because this takes it to Article 27 of our Constitution that promote it talks about grounds of discrimination, with gender being a ground for discrimination. And in instances and in processes that I've engaged in, particularly in Turkana, and I know Nakuru quite extensively, in Kisumu, in Mombasa, and Nairobi, we normally insist on 2/3 gender because then the statute, be it the Community Land Act, be it when you do settlement committees, as in the Land Registration Act, then the 2/3 gender rule must prevail. And even when you do settlement schemes, when the settlement committees must have the representative of the women, representatives and the representative of the youth, to ensure that the voices of women is then heard. I would like to bring forth as involvement of women in ADR and alternative justice systems.
Thank you, Orlando. Senior Maweu, I know there's a document you want to share. You have the rights to share the screen even as you respond to Felix. Karibu.
So it's a bit bulky and it's in PDF. So what I'll do, I'll share the document, but it basically documents how best we can mainstream gender in in grievance mechanisms, especially for businesses. And it's quite practical. It looks at all the steps. How do you engage them? Do you empower them? And in the wider conversation on AJS, it's about being deliberate, even in the set AJS mechanisms or the AJS panels. To what extent are we involving women? And it may interest us to know that even in the most traditional of communities that were traditionally regarded as being very rigid on culture, there's that wide acceptance that women can still be traditional dispute resolution actors. Isiolo is a very good example. They have different councils of elders that have women participating in the resolution of disputes. A very interesting question on compensation and what happens, how was it arrived at. So a bit of history, allow me to just highlight that it started with a conversation around the panel of experts that was appointed by the president to look into the issue of compensation, and it was limited to victims of public protests and demonstrations, maandamano basically, and there was a time limit, it was 2024-25. Those who followed would appreciate that the court did not agree that the panel was constitutionally constituted and it was declared unconstitutional. And there were other efforts to try as much as possible to amend the Gazette notice towards compliance. And the court was equally satisfied that even the amended Gazette notice was not fully constitutional, because that role was a reserve and the mandate of the Kenya National Commission on Human Rights. I am happy to have participated in that litigation, but also to have participated in the processes after, where under Article 2542, the President required the Commission to develop a reparations framework and submit, publish, and publicize a reparations report. And that happened on Monday. The report was submitted on Monday. Now, further to that, it's a question of compliance. But for us, the approach that we took, we looked at reparations broadly, and Mr. Orlando had already highlighted this. When we look at effective remedy, compensation is just one tiny component of the remedy or the reparations discussion. Internationally, there are basically 5 key pillars or 5 forms of reparations. The first one is satisfaction, looking at such acts as even issuing an apology, memorialization, I'm sure you've seen monuments from time to time erected to just preserve the memory of some of the heroes or some of the human rights defenders, even some streets that are named after very vocal, very vibrant human rights defenders. It can also be restitution, basically giving back that which had been taken away. If you look, for instance, because we are having a conversation on land rights and access to justice and communities, for those of you who may have followed the Ogiek case, they went to the African Court on Human and People's Rights, and part of the claims they were making is that part of the land that is currently categorized or classified as public land within Mau Forest is actually their ancestral land. The court agreed with them, found that that land is theirs, and ordered for restitution. Basically giving back. It could be also in circumstances where someone is being held in custody, and remedy or restitution in this context could take the form of just releasing them, giving back their liberty, and having them continue to enjoy their rights. You can also think of rehabilitation, whereby you look at it from either a medical or a psychological perspective, depending on the needs that are manifesting in such victims. So that is still part of ensuring reparations or the right to remedy in the specific circumstances. You can also think of now what everyone is apparently talking about, the question of compensation, where you basically provide monetary award for the harms and the violations that the communities or the individuals have suffered, just like the courts have been doing, and just like what the African court did in giving an award of about 157 million to the Ogiek as a community. But more importantly, and the conversation that we are also having and continue to have as a country, is guarantees of non-repetition, so that you don't keep remedying every other time, you don't keep spending, especially when it's taxpayers' money, on providing compensation. But how can you meaningfully address in a more holistic and sustainable manner the structural causes for some or the ones that allow these violations to occur? So for us, some of the recommendations that we've made over and above compensation is looking at structural changes, training for law enforcement officers, legislative and policy institutional changes, and we proposed key among them. I will only highlight two pieces of legislation. One is a reparations act, replete with a reparations fund that sustainably provides the funding for resolving and providing whatever compensation or whatever awards have been given, and these are reparation measures that have a financial component. And there's also a proposal for a board to operationalize and to administer that fund. We've also proposed that it's time as a country we have meaningful conversations on how best we can operationalize Article 7 rights. It's not the first time, and it will not be the last time, that Kenyans are taking to the streets to express themselves. And the Constitution guarantees them the right to picket, the right to assemble, the right to demonstrate, and the right to present petitions. And because we all live in this country, we appreciate that there have been concerns about human rights violations in the context of the enjoyment of Article 7 rights. Some of the conversations that we need to have as a country is how can we best operationalize that? What would be required? What would be the standards of engagement? What, for instance, would be the appropriate remedy mechanisms for the violations that occur in the context of people exercising their Article 7 rights? And what accountability mechanisms are we proposing, especially for the use of force? Because there have been cases that are clearly documented where the responders used excessive force, and force which was not even necessary in the first place in the context of trying to contain some of these protests, some of these demonstrations, and some of these pickets. So it's a wider conversation, but basically navigating us towards guarantees of non-repetition in terms of what needs to change. Now, from a business and human rights perspective, tying these together, that is why there's been a proposal and there's already a framework in place, human rights due diligence framework. As a business, you already know that if you go to operate in a certain environment, you're likely to occasion or contribute to a number of human rights infractions. Think of the extractives. It's very clear you will need land. That land most likely is occupied by people. That is likely to lead to displacement or a violation of their right to land or their right to housing. So before you even engage in the investment itself, what are some of the mechanisms that we can put in place to mitigate those violations or the impact of those violations, or even altogether prevent the occurrence of those violations. So it's a much, much wider conversation in terms of what really needs to be done to sustainably address some of these concerns. In terms of what is likely to happen, it's a wait and see, but we remain hopeful that the recommendations of that reparations framework will be taken into account. And because you asked very expressly about compensation and the amounts, please note that what the Commission gave is a recommendation, and it's the basic, the floor. We didn't provide for a ceiling, but we also provided for factors that should be considered in upscaling the award that is to be given in the case of compensation. We looked at things such as the impact that violation has had on the victim, the duration that the victim has borne the impact of that violation, amongst other factors. I can stop at that and cede the floor back to you, Sally. Thank you.
Thank you, Cyrus, for that extensive response. I can see more questions are coming up. We still have a bit of time, about 15 minutes before we finish. Allow me to give Joanne a minute to share a comment before we proceed. Karibu, Joanne. Is Joanne still with us?
Yes, I am, Sally. I don't know if you can hear me.
Yes, clearly. Proceed.
Yeah, I'm really picking up a lot from the discussions we are having, and the questions are also very insightful. Just two reflections. The first one is on what Rosalind asked, potentially having a ministry of or a body tasked with looking at business and human rights. And I think I'd like to flip that and ask, especially when it comes to justice, if all the existing institutions, or we can institutionalize justice as a fundamental principle. And I know I was just looking at our national values and principles, and I think there are so many elements of justice in those principles that maybe can qualify as justice. But for me, it would be very curious or more of a long-lasting strategy if we look at all these institutions and bodies embracing justice as a principle rather than trying to create a whole new system or a whole new body that just focuses on business and human rights. Why? Because given how business and human rights is, or the landscape of business, very many institutions, have a business component. If you look at agriculture, there's agribusiness in that. You talk about issues land, issues energy. There are so many cross-cutting authorities or bodies and commissions and systems that exist that will interface with human rights. So it would be more long-lasting and more impactful if we say, can all these players, all these stakeholders just embrace justice as a fundamental principle? And of course, here I'm talking, more of idealistically. Practically, it's a different conversation, but then ideally, that is where we could start. Can we all embrace justice and embody justice in our in the existing systems? So again, a curious thought to just bring, and maybe we'll elicit some questions. My second reflection is on the general conversation we're having today, and the aspect of multi-doors to justice. And for me, there are only 4 things that I think we need to work on so that we can say all the doors are working or all the doors are open. The first one is knowing the door, awareness around the systems that exist, be it AJS, ADR, the court systems, just knowledge on how they work, how they function. And I've seen in the chat, we have a lot of human rights defenders. Part of that, the place of a human rights defender is enhancing that knowledge on the different doors that exist. And I'm really happy because this conversation is pointing at the different doors and how the different doors can be made better. The second thing is being able to approach or participate in the door. Approach the door and participate within the door. And that's where we're even having conversations around women, in justice. Are they able to participate? Are we able to participate as women? And any system, regardless, needs to be approachable. That when there is a human rights violation, you know where to go, but you can also go there. You are confident enough to go there. The third one is that you trust whatever happens once you're through that door, that the system is okay. There's trusting of the process. You trust that it is fair. You trust that you will be heard. You trust that the outcomes will be fair, or that you have so trusting that thereafter, once you've approached, then you're able, you will be able to present your case and be heard. And whatever the door, you need to be able to trust that the proceedings will make sense, be it an OGM or a private sector grievance mechanism, that that it is fair. You can trust that there will be equality, and it will be a fair determination. And lastly, the outcome. You can trust the outcome. You can trust that it will be fair. It will be enforceable. I think that whatever the door we are looking at when it comes to addressing business and human rights issues, at the end, the product must also make sense ultimately. And that's where I'm hearing the conversation on compensation, hearing, remedy basically as part of that conversation. So if we think about it as simply as that, then we can critique whatever exists right now to see, do we know about it? Can we go and approach it, or can we participate in that system? Do we trust the proceedings within that system? Whether it is elders, whether it is the private sector, do we have trust in whatever is happening there? And lastly, that whatever they say is enforceable. There's accountability around the outcomes of whatever process ultimately. So all doors can be effective at whatever stage. We just need to make sure that we embrace all aspects of said door. So much, sorry to keep hammering the metaphor here, but those are my two reflections on the topic. Thank you.
Thank you, Ms. Kirimi, and thank you for reminding us that maybe we should take justice or propose justice as a fundamental principle in our constitution. Thank you so much for those reflections that kind of put also our discussions today in a summary or in a snapshot. Thank you so much. Just to mention, ladies and gentlemen, that the tool or the guidance that Maweu was talking about, that is the guidance for gender responsive operational level grievance mechanism tool. We are trying to share it. If we are not able to share it in the comment, we'll be able to share it with you after this webinar. I see questions, more questions even as we come to an end for this webinar today. And Kiplangat, I think your question has been answered by Ms. Kirimi, because you're asking that where we are coming from. How do we know about the rights, especially the employer and the employee rights? And we have alluded to it in the discussion, more sensitization, and I think also knowing the door. That's what Joanne is also proposing. We'll be able to respond to that. And I think this project also offers that platform where we can continue to learn. John, I had seen a hand up from Kathieni. Evelyn, are you able to speak? Yes, Kathieni, Evelyn. As we wait for her, there's a question from John. I don't know if this has been answered. He's asking that how can a community that has been living in the squatters for more than 10 years, and in 2017, some group of surveyors accompanied by the chief and their administration claiming to have been sent by the government to survey the land into 50 by 100 plots, yet there was a lot of displacement. Others were taken to marshy areas where floods had occurred during the rainy season, and since then there has been dispute within the community, and there was a case filed in court, but up to date remedy has never been accessed for this problem. I think Maweu, you get the question. I could see that your already responding, but both yourself and Orlando can respond. There's also a question from Helen. She's asking what safeguards are in place to protect the whistleblowers, and I think that's also in regards to the retaliation question that we've been discussing. I don't think I can see any other question apart from the three. Yes. Also, I think from Helen, she's asking, what lessons have been learned from the past cases of business-related human rights abuses, and how are those lessons shaping the current practices? I think those are the questions that I can see now. There's also a comment from Asena. I think she's saying that before harm, we should proactively identify the issues, prevent them, and then engage widely. And after harm, we should be able to respond to those harm, provide remedy, and also improve and guarantee non-repetition of the harm. So I think there's also a question from Lewis. Allow me just to read the question so that we save time. That how do Kenyan courts quantify reparations and constitutional damages in cases of unlawful loss of life arising from protest-related police action, and what legal principles guide the assessment of dependency loss or constitutional violation and vindictory damages in the absence of market-based valuation of human life? I think those are all the questions that I can see now. So I want to welcome Orlando and Maweu to respond. I want to start with Orlando, kindly. You can take the floor.
On the question that's dealing with the land, is that there are normally settlement committees in instances where there are resettlements. So I don't know the facts yet, but Sally perhaps will liaise with the human rights defender so that then we got the requisite documentation for purposes of support. But as such, what we know as always is that before such a process commences, there's normally a settlement committee that has got a list of those who are affected, who are due to benefit from the resettlement, and as such, then it's always the basis that upon which the plots are located before that ultimately proceeding to issuance of certificates of titles or leases. So I think I'll leave it at that, Sally, based on the facts that have been provided. Thanks.
Thank you, Orlando. Maweu, you can go ahead, and as you respond, I think you can also respond also on a question from anonymous attendee, and is asking, that is if you'll be able to, that recently the High Court found that Gachagwa's Article 50 right to fair hearing was violated during Senate proceeding, yet declined to reverse the impeachment due to constitutional finality. Want this precedent signal to state agencies that right violations are acceptable so long as the process is completed quickly before courts intervene? How do we protect communities from losing access to effective remedy for irreversible harms like evictions or environmental damage, when this case can be cited to justify violation with damages only? So that's the question. Senior, you can go ahead.
Thank you. So I'll take a couple of questions. I think in the Q&A there was a request for the document to be shared. So I've already shared the link. I hope you can access the document. But even if you're not able to, I'll share it with you, Sally, and you can also share it with the participants. So the starting point is that, unfortunately, as a country, we do not have whistleblower legislation. I know there have been conversations and a lot of advocacy around that, and we hope moving forward, as we also intensify the advocacy, that this is one of the things that the state would be keen to do. Because I just spoke about a reparations framework and recommendations that we gave, one of the recommendations was that Kenya needs to ratify and implement the Convention on Human Rights Defenders. And this is for the reason that human rights defenders are oftentimes at risk. They do quite a lot, and because of their active engagement in defending the rights of communities and individuals, at times they are also facing threats because of what they do. Are there safeguards within communities? Can HRDs work together? Can they leverage on existing networks, including CSOs? Those are some of the practical things that could be done to minimize exposure to risk, including situational awareness and capacity building and training on security management, especially for human rights defenders. On the lessons that have been learned, one is that there's no uniformity in the way different businesses approach grievance handling. And part of what we did as a national human rights institution was to think through holistically and in a more sustainable manner, what is it that we can do and the value add that we can bring. And we had consultations with different businesses, different CSOs, different actors, including the Office of the Attorney General and other state actors. And we developed model guidelines that we believe businesses can adopt and customize to their specific needs for them to develop their operational grievance mechanisms. And that is a document that is equally publicly available on our website. I will also be able to share the link for that document. Again, we continue to have conversations, especially with businesses, the state actors, and even communities and civil society actors on matters business and human rights broadly, including their obligations, the duties that they have, and what they should do in the event of a breach to ensure that those who suffer those violations do get access to remedy. Currently, there are some known businesses publicly that have developed operational grievance mechanisms, and that also provides places to draw lessons. Mechanisms functionally effective? Are people using them? What kind of disputes or grievances are people reporting? And what is the percentage rate in terms of resolution? And also the turnaround time that it takes for these disputes to be resolved within these mechanisms. Kakuzi has one. They call it the Skika platform, basically Be Heard, or yes, Uskizwa too. And it's in the public domain that mechanism exists. So it's also a question of us asking ourselves, for those who already have these grievance mechanisms, how effective have they been in resolving some of these disputes, and what are some of the lessons that we can learn from these conversations. I also observed that there hasn't been a lot of litigation in matters business human rights. There are few cases that really stand out, and they are very clear on the obligation of the state and the obligation of businesses. But historically, our approach as a country and as different countries has been that you claim as against the state, but you are in an environment and in a context where businesses are legally bound and they have various obligations. If you look at Article 20 of our Constitution, it's clear that every person has certain obligation when it comes to human rights, and businesses, in the strict sense of the law, are legal persons who can and have actually been sued because of the human rights violations that they either committed, contributed to, or allowed to happen. So we hope that moving forward, one of the lessons that we need to take with us is there is a need to also test the waters and have jurisprudence which is very clear, especially on the scope of businesses and the obligations that they have, and more significantly, especially when we have multinational corporations that seek to avoid liability in the countries where they're operating, citing that they don't operate there or they're not registered there, subject to the jurisdiction of those courts. I'm very happy that we are having this conversation at a time when there are cases that have been filed against Meta, basically the parent company for Facebook, WhatsApp, and a few other social media platforms. And one of the arguments that arose was whether and to what extent they are bound by the Kenyan jurisdiction and whether or not they can be sued in the Kenyan courts. The Employment and Labor Relations Court confirmed that it has jurisdiction. The matter went to the Court of Appeal, and it will be interesting to see ultimately how that question is settled, because appreciably most multinational corporations are now shifting to the digital space where regulation and legislation has not caught up with the practice. Thank you. I believe I have not left some of the questions where I think there's a question around harm to communities. I would just approach it from the basic principles on a remedy. And for me, an effective remedy is one that substantively addresses the needs of the communities to their satisfaction. And that brings in a few other elements, most of which I've already highlighted. Questions around rehabilitation, restitution, compensation, but more importantly, guarantees of non-repetition, including accountability for some of those violations, especially where the perpetrators are known. Thank you, and back to you, Sally.
Thank you so much, Orlando and Mawel. I think we do not have any other questions. I think the discussions today have been very rich and speak to some of the issues, some of the questions that some of the participants have been asking. And as I had mentioned earlier, that we are starting a series of these discussions. And if there is any issues that maybe have not been dealt with or discussed in this webinar, it's our hope that we'll be able to discuss them in the series that are coming. There is a link that has been shared in the Q&A or the chat box. It's a feedback link that will also help us plan for some of the webinars that are coming up. We ask that please you respond to it so that we continuously enrich the discussions that we'll be having. I don't want to keep you beyond one because this webinar was scheduled for the 2 hours. Not to worry, if you had any other questions, as I've mentioned, we'll be able to continuously discuss it. Allow me to have this session, to close this session. Maybe I know our speakers have spoken a lot, but maybe their closing remarks, maybe in 1 minute or so, and then we'll be able to close our session today. Allow me to start with Mawel, just your reflection and closing remarks for today before we end. Karibu.
Asante sana, Sally. For me, it's a timely conversation. Access to justice should be a lived reality. The law promises us many things, but communities and individuals are more interested in the practical enjoyment and realization of their rights. People go to court, especially communities, because they are suffering. So it is equally important that the outcome of those efforts, especially where litigation has culminated in a judgment, is implemented. So I hope as we have these conversations, we'll also keenly look at how best we can move from judgment on paper to justice that communities enjoy. And finally, for me, a remedy has to just answer a simple question or pass a simple test. Does it guarantee the community's future stability, their self-determination and well-being, or is it just for the benefit of the business? If a remedy is not effective, it's just adding to the cost of doing business, and it's time that business has realized that you can only sustainably run a business if you respect rights. Thank you.
Thank you. Moving from judgment to justice. Yes, Orlando, also as in your position as the executive director, we can have your closing reflections or remarks.
Thank you, Sally. First is to thank you, Sally, for putting this together alongside your colleagues and for extending the invitation to Cyrus and myself to contribute to this timely conversation. Secondly is to thank our human rights defenders and practitioners who have joined this conversation. Normally, it's never an easy thing because rights must be claimed, and in most occasions, we don't have an opportunity to have rights served in a platter. So the work that the human rights defenders do, the work that Sally and your colleagues do, is that which is appreciated across board in the social transformation that we so seek for our countries. I further extend our appreciation to the Danish Churches, the European Union, for this timely conversation. And that to sustain this is that we must practically continue engaging with it So as such, that I want to call upon our colleagues who are present in this meeting that to feedback with you, Sally, so that then the topics that perhaps have not been covered today then could be covered in the next convening. Thank you very much. I wish you a blessed day, and as also we are nearing the end of the week. I wish you a pleasant weekend. Thank you very much.
Thank you, Bueno Orlando. And now I want to thank all of you, our participants, for actively engaging. We recognize your inputs, and once again, asanteni sana sana sana. We look forward to continuing with the discussions and also advancing practical solutions that strengthen access to remedy. As we have been told, effective remedy addresses the community needs, and just not addressing them, but addresses them satisfactorily. So thank you once again. We'll be able to share details of our next webinar. Asanteni, and have a blessed afternoon.
Appreciate it. Thank you, everyone. Have a good afternoon.